Hi there, my name's Alex Woods. I'm a civil litigator and I work for a firm in the City of London. I'm running a unit called Redwood Legal, which is a division of Ferguson Solicitors LLP. We've been working in conjunction now for about 3 months, and Fergusons are an experienced boutique, I suppose is the word you'd use, small firm with a big reputation type employment litigation firm. They've been bringing claims on behalf of employees, bankers against banks now for a number of years. Redwood Legal is a unit which is dedicated entirely to the financial irregularities sector. I have been a criminal and civil litigator for over 15 years. I initially worked for a very experienced and probably the most talented criminal litigator that I've ever met at a firm called Humans a number of years ago now, and during those years I gained a lot of exposure, a lot of experience of white collar fraud of really quite a high level of complexity, whether it was working as an assistant to Peter Human or whether it was running my own cases. So the work ranged from, actually started off doing a lot of police station visits in and around Greater London, but quickly moved on to high yield investment frauds, evading VAT on fuel, to carousel frauds, to an advanced fee frauds, and one of the most interesting cases I had was outside the jurisdiction, a confiscation proceedings in which we successfully delivered a good outcome for a client, where the serious fraud officer trying to confiscate all his assets, both here and overseas. This has informed my work as a civil litigator, and I think enabled me to become much more of a tenacious and determined civil litigator than had I, say, been in a non-contentious area, had I not been in crime. It was an incredible background for somebody who wanted to get into the world of financial irregularities, where, of course, the line between crime and simple unlawful activity is very, very, you can probably squeeze a Rizzler paper in between the two, as I'm experiencing. Now, I've brought a number of cases. For the past 3 years I've been bringing into payment protection insurance cases. I've been focusing exclusively on the payment protection insurance sector as a springboard into setting up the financial irregularities unit in the long term. And the battleground has shifted somewhat since the British Bankers Association, all the big banks threw in the towel on the payment protection insurance issued in the spring of this year, but it's still very much there. What has happened now is the big banks have set aside 7 to 9 billion to manage the payment protection insurance scandal, but they're still fighting tooth and nail not to give back any more money than they're absolutely required to. So, for example, I brought a claim against MBNA. First, there was an outright denial that they'd missold a payment protection insurance policy. Then they made an offer of £3,750, my client, and then we had to take them all the way to court. We spent a whole day in court with MBNA, and I remember the young barrister spent most of his time on the telephone to the executive's head office, Bank of America somewhere, which protracted proceedings. Anyway, they finally coughed up £6,750. So that's one small, it's a small quantum, but it was quite an important watershed case for us and for the sector in general, in terms of establishing the principle that the value of a payment protection insurance claim is not just the amount of premiums, it's the interest on the premiums, it's the future interest on the premiums, it's the compound interest the bank has charged on the premiums. So they're trying to wriggle out of quantum. And where you've got a product that's been sold onto a loan, often dumped onto a loan as a big fat single premium, you can see how very high levels of interest can be earned over the life of the loan, and on a credit card, very high levels of interest, compound interest, the eighth wonder of the world, can be added to a poor client's liabilities without them really realising. And you do need some level of complexity in order to bring these claims. Some level of complexity. In certain cases, the services of a lawyer do not go amiss in maximising the refunds that you can get on a payment protection insurance claim. It may take a little longer, but the dividends are there. Now, that's a little bit of background to me into the work, to the litigation work that I've been doing over the past few years. Now, in terms of what we're doing as far as fellow professionals are concerned, which is the area that we are now very firmly in, we have formed relationships with a number of insolvency practitioners in the Greater London area, about 4, probably 5 now, and we've started to take on large quantities of individual voluntary arrangements, IVAs, where we represent the insolvency practitioner with their IVA supervisor hat on, in order to maximise unrealised assets and introduce them into the IVA fund for the benefit of the creditors, for the benefit of the insolvency practitioner because he earns a windfall fee, and I think also a benefit to the debtor client if for no other reason than the IVA can go successfully to term and there aren't any problems or issues during the life of the IVA. Rather depends on the way in which the IVA proposal has been drafted, but I think that there is benefit to all in realising a payment protection insurance claim from within an IVA. We have just signed an agreement. We're now processing upwards of 600 IVAs with a insolvency practitioner in the area, not a million miles away from this office in Gough Square. And we have a office in Colchester now, and we can process much larger quantities. So, our doors are open for business if you are an insolvency practitioner and you would like to hear more about how we can help you in terms of realising financial irregularity claims or assets into an IVA fund. Indeed, in time, we would like to be able to help you in other areas too. Financial irregularity claims within bankruptcy, for instance. Completed, we can also help you with where IVAs have been completed. And insolvency practitioners can enjoy introducer fees where we've got secured charges on a debtor client, which is an asset which typically falls outside the IVA, and we can bring an action. PPIs commonly missold on second charge mortgages, and they're often of high value, and we can bring an action against commonly against a non-status lender for payment protection insurance sold on top of a second charge mortgage. Now, thirdly and lastly, we can add value. This is a sales pitch. It sounds like a sales pitch. It feels like a sales pitch. It probably is a sales pitch. We can add, and this is probably the unique selling point of Redwood Legal, one of them. Can there be more than one unique selling point? So anyway, this is the main selling point and the main benefit that Redwood Legal offer to the insolvency practitioner sector, which is something that we can offer over and above the claims management companies out there who are our competitors, and that is the legal advice and assistance. Because I think that going forward, and let's face it, the banks really are struggling to shore up their balance sheets these days. We can offer legal advice and assistance on some tricky areas, such as set-off. We are finding, and the figures are on the up, that in terms of the claims that we're litigating, the banks are trying to use the excuse of set-off. In other words, they are trying to set off a payment protection insurance claim against their own debt and not introduce it into an IVA fund. It's a minority, and where the debt has been sold, and commonly it has been sold, then that's not so much of an issue. But it is, I would say, there's a significant minority of claims that need some attention given to them in terms of the legal set-off issues. Now, more importantly, it means that in terms of running a more wholesale IVA business, we can simply jump tracks if it appears that a lender is being difficult and litigate the claim rather than run it as an ordinary complaint through the claims processing arm. So we can, if you like, we've got a more of a large-scale processing operation running, and within that is a litigation unit with real teeth, and then within that is simple legal advice and assistance that we can provide to you on an hourly rate basis as lawyers, or indeed as part of the deal. We can offer you some legal advice and assistance. and we're very well connected and working closely with counsel at South Square Chambers, the insolvency specialists. So that's all. I hope that that's given you some sort of a window into what it is that we're doing. It won't be the full picture. I'm trying to keep this down to the shorter picture that I possibly can, obviously. But if you've got any further questions or queries, please do not hesitate to pick up the blower to me, Alex Woods, or any of my team, or, of course, to email us at info@redwoodlegal.co.uk. Many thanks for your time, and look forward to speaking with you and to doing business with you in the future.